Good afternoon. Welcome to today's webinar, The Life of a Lawsuit, an interactive professional development course designed to help expert witnesses understand litigation more fully and work more efficiently with attorneys. It is our goal to provide experts with an overview of a lawsuit and explore the following topics and how they relate to expert witnesses. Rules of civil procedure, initial pleadings, schedule orders, written discovery, depositions, settlement, and trial. Our presenters for this webinar are Craig Heidemann and Nathan Duncan. Mr. Heidemann is a shareholder at Douglas, Haun Heidemann. Mr. Heidemann's practice is limited to serious personal injury claims, wrongful death, class actions, civil rights, pharmaceutical products liability, felony and misdemeanor criminal defense. Throughout his practice, Mr. Heidemann has recovered significant dollar settlements and judgments for his clients. Joining Mr. Heidemann as a panelist is Mr. Nathan Duncan, an associate at Douglas, Haun Heidemann. Mr. Duncan attended law school at the University of Missouri-Columbia, where he earned his JD degree in 2007. Nathan is a member of the 30th Judicial Circuit Bar Association and the Missouri Bar. He is also admitted to practice before the U.S. District Court, Western District of Missouri. This webinar will be divided into 5 sections. Our panelists will present for 10 to 15 minutes, and then we will have a 7-minute Q&A session. When we have the Q&A session, I will open up the Q&A panel, which will be found on the right-hand side of your screen. Please use this panel to ask your questions. I'm going to turn it off now. We will then have a 10 to 15-minute presentation followed by a second Q&A session. We will end the session with a short wrap-up by our panelists, Mr. Heidemann and Duncan. Please use the Q&A feature to ask questions that directly pertain to the subject matter. Mr. Heidemann and Duncan will choose 3 to 4 questions out of each session's answer verbally. We will be sending out a link to an archived recording of this webinar later on today, and we do ask that you take time to fill out the survey that will appear on your screen after the webinar is over. We will also be announcing the second part of this introductory series at the conclusion of today's session. Look for a formal announcement in the coming weeks. Sit back, relax, and enjoy. I'm now going to turn it over to our distinguished panelists, Mr. Craig Heidemann and Mr. Nathan Duncan. Craig and Nathan, it's all you.
Medical negligence to other kind of products liability cases. Found many times that the experts that we were using didn't really appreciate the full scope of what a lawyer is doing in trying to move a case from alpha to omega. And in moving the case from point A to point Z, there's a lot of steps along the way that a lot of experts didn't really understand. And we thought, we could really do our job a lot better if our experts are helping us craft our case from point A to point B. And one of the things that we kind of came up with to explain to our experts this relationship with lawyers and experts is symbiosis.
Well, as you all know, this is Nathan. As you all know, symbiosis, I looked up in the dictionary and had to turn to Merriam-Webster. Symbiosis is where 2 organisms, 2 things depend on each other to exist. And, as we looked at it, we thought that attorneys and expert witnesses really enjoy this type of relationship. We depend on expert witnesses in the work we do to accomplish our goals, and we certainly satisfy some of your goals as well.
A lot of television shows are devoted to lawsuits, and lawsuits are very interesting to members of the consuming public, but what we don't talk about is civil procedure, the rules of civil procedure. The rules of civil procedure are those things with the rules that we have to follow as lawyers, and if we don't, we can suffer some pretty harsh consequences. And those rules relate to expert witnesses. In federal court, we have Rule 26, which at the very outset of the lawsuit, we have to agree upon, and the court has to approve a scheduling order that says when our experts have to render their opinions by. And, you know, experts need to have a voice in that process.
Well, and it's important because these rules of civil procedure, whether they're in effect in federal court or state court, guide this life along. They're the framework by which a case moves forward.
You know, the lawyers can set all of the deadlines that they want, but if they're impossible for the expert to meet based upon his private practice commitments or his personal commitments, if the expert can't meet the deadline, that's going to create problems down the road, and that's why we try to involve our experts in the deadline-setting phase of the lawsuit, which occurs at or near the birth of the lawsuit.
Well, and a lawsuit is begun with whatever, it's either called a petition or a complaint, depending on the jurisdiction. Someone has some kind of problem, some complaint, they've been wronged in some way, and they file this document with the court explaining what that wrong is. An important part of the petition and complaint, obviously, is setting forth kind of the legal framework of the basis for their lawsuit.
Now, these petitions or answers, depending on whether you're a plaintiff or a defendant, they are really rule-driven. And if you don't allege certain facts which legally make up a cause of action, which is what we call a lawsuit as a cause of action, you can get thrown out of court, either outright on a motion to dismiss or later on down the road in a motion for summary judgment. If some of you as experts have had to sign affidavits, which perhaps your lawyers have used in connection with motions to dismiss or motions for summary judgment, that's where you try and point out that the other side has failed to allege a sufficient cause of action, and you get the lawsuit thrown out before it even goes to deposition or to a jury trial. Likewise, there may be answers, counterclaims, cross-claims, third-party claims, and that's where the parties involved try and frame what their complaints are against one another, or what their answer to the alleged wrongdoing is.
Well, it's important to remember that as expert witnesses, you have a chance to affect and to play a role in the drafting of these first documents, these petitions, the answers, any third-party claims that might come. Some lawyers have this shoot first, ask questions later approach, where you rush to the courthouse, get your petition on file, and then after say, well, maybe I should not have filed that lawsuit.
I call that ready, fire, aim, and it's not a good way to practice litigation. We've had the advent of tort reform in the last couple of years, and medical doctors from state to state have been a big proponent of tort reform, and in most of the tort reform litigation or lawsuits that have been passed in the various states, lawyers are required to attach expert affidavits saying that there's merit to the lawsuit to the initial pleadings. Some lawyers are better at doing that than others. In Missouri, for instance, we don't have to attach that until 90 days after we file a lawsuit, but I thought we'd give you an example of where an expert's involvement early in the case really exposed us to some problems with the case that we were considering taking.
We had a prospective client come through the door, and she had some complications when she had her child. There were some questions about how long the doctor should have taken before initiating an emergency C-section.
The baby was not progressing, and the fetal heart tones were going south relatively quickly, and they started paging people, and no one would come to help her. And we really thought that it sounded like a case where there was some significant liability.
Well, and from our lay experience, we have kids, both of us have kids. We thought, well, this sounds bad. Somebody should be sued. But we took it before just rushing to the courthouse, getting a petition on file. We consulted with at least 3, maybe 4 experts, have them review the medical records to give us their feel on how this woman's case was handled.
And the consensus among all 3 of these experts was we weren't happy with the first one that told us that the standard of care was met, and we thought we'd check with another one, and we checked with a third one, and the consensus was good things happen or bad things happen to good people, and this wasn't a case where it should be pursued in litigation, and so we let it go. There's a lot of opportunities for experts to be involved, and the observation that we had is that, you know, the experts that we had relationships with charged us a fair price. They got back to us quickly. They gave us well-reasoned opinions. They took the time to listen and understand. And with that information that we got from our experts, we believe we were able to make the right decision for our client and explain it to her so that she understood why we weren't able to go further.
Well, and one other thing, you know, besides helping craft this, determining whether you should file a lawsuit, there's also the opportunity to explore different claims or responses to those claims.
After the lawsuit is filed, the next thing in the life of the lawsuit is scheduling orders. Scheduling orders, I always say that we should staple them to the wall of our office because they're orders from the court. They have the effect of an order, and they say when things are going to occur. And if you miss the deadlines, it's oftentimes not good for a defendant or a plaintiff.
Federal court, there's a Rule 16b, which mandates that a scheduling order be entered, and they can take different forms. They generally set out deadlines for close of discovery, when trial is going to happen, when parties are supposed to disclose certain things. State court, it depends on what jurisdiction you're in, whether there'll be a scheduling order in place.
Oftentimes, if the case is serious enough to call for expert involvement, and it's a state court case, you can expect that the state court judge eventually is going to enter a scheduling order to tell the parties when things are to occur. And just as I would suggest that attorneys should staple the scheduling orders to their wall, so should the experts, because if an expert knows that his opinion is going to be due May 1st, and he hasn't heard from the lawyer to provide him with depositions records by April 21st, the expert knows that somebody's expectations are not going to be met, and maybe that would be a time to pick up the phone and say, hey, you know, we're coming up on this deadline. What's your plan? I can't help you unless you provide me with the information that we had initially talked about.
So, like I said, one of the important aspects of the scheduling order is it sets forth deadlines for the completion of discovery. Discovery can take a couple different forms typically. There's written discovery and then non-written discovery.
Written discovery would include interrogatories or written questions that the other side has to sign under oath. Generally, they're answerable within about 30 days. Request for production of documents, where that can include electronic evidence now, emails, data.
Twitter, your tweets.
Yes. Nothing is safe. Facebook, Twitter, LinkedIn, any of that we can get through written discovery now in federal court and in most states. We can also ask requests for admission, where we say, you know, admit that Dr. So-and-so failed to do A, B, or C, or in fact, if you're defending, admit that Dr. So-and-so did A, B, and C. And so experts can help us in all phases of discovery. Experts need to give their lawyers during discovery their wish list, we call it, their Christmas list of wishful things that they would like to have.
Well, because obviously, as experts, your role is to create and formulate your opinions on what happened in a certain case, and to do that, you require certain data. As attorneys, you know, as an attorney, I may not have a great idea of exactly the important data that you need to formulate your opinion in an efficient way. Having an expert tell me, hey, Nathan, I need to know this is extremely helpful.
We're going to open up, Matt, the opportunity for written questions to be typed in now while we finish up with this last slide. The experts' involvement in discovery, I think, is really an opportunity that experts are missing at this particular in their relationship with attorneys. Sometimes, you know, the attorneys only want their experts to say, to opine on negligence or causation or damages, but as attorneys, there's so much more to a lawsuit that we do that we have to prove than just those little elements of the case where we need expert testimony. I mean, I think an expert, a motivated expert, could really help us from point A to point Z with much more than they currently do. The fear that lawyers have is that it's going to cost us a small fortune, and that we don't want to give an expert a blank check to come help review every discovery item that we have or all of our discovery responses. But I think for motivated experts that really want to go the extra step to deliver a good, I'll call it a product, to their attorney that's hired them, they should offer to be involved in those phases of discovery. Now, there's some issues regarding the discoverability of expert reports. If you might have a consulting expert and a testifying expert, and the state laws vary wildly from state to state on what is discoverable. So depending on the state that you work in or that you offer an opinion in, the attorneys may not be able to use that extra service that you might be able to provide, because if you did that, it might open up everything that you said to discovery.
And the other aspect of this is, and this will be a common theme through other parts of the presentation, is the speaking of the language. As an expert, you may need certain documents, certain things to help formulate your opinions, but getting that from the other party involved in the lawsuit requires a little bit of the legal language. And so the lawyer will step in at that point, and through the interrogatories, depositions, which we'll get to, request for production, can use the tools that they have to get that for you. Conversely, the lawyer will not speak the same language as medical experts, engineering experts, the different kind of experts, and will rely heavily on you to help them speak that kind of language, to know exactly what to get from the other side.
We're going to go ahead and open it up to questions now. We've got one here. Well, this is from Owen Rubin. He asks, define motivated. I think I said we had a motivated expert. Often we're limited to what we report and ask not to go too far outside of the boundaries. How does one decide how motivated to actually be? How do we as experts know? That's an excellent question. Oftentimes we as lawyers are worried about whether or not an expert witness is going to say something that's going to come back to haunt us later. So we might tell the experts not to write anything down until we've talked first. I think what Mr. Rubin could consider is whether or not you're going to be hired as a consulting expert or a testifying expert. The consulting expert in the jurisdiction we practice in is the expert where everything is private and confidential. We're going to hire the consulting expert to help us figure out what the strengths and weaknesses of our case are. We might ask that expert, what is the other side going to say to the case? What do we need to do to prepare? And they're going to answer those questions for us. They're going to help us craft our discovery and understand what the strengths and weaknesses of our case are. So I think to define whether or not you will have a consulting role in the case would be important to deciding how motivated to be.
Another question from William Nelson. He asked about our position on attorneys reviewing reports prior to being finalized. I think there are two schools of thought on this, I think. The one that we use in our practice is we're not the experts. We want to avoid at all costs the appearance that we had any influence at all on what the report, on the expert generating or articulating his or her opinion. In our minds, the job of an expert is to take a certain set of data, facts, plug it into a scientific formula, and spit out a result. And, what I as an attorney think of the case, or, I guess my potential bias in the case should have no effect on how that result is reached. And to the extent that the report is a reflection of the expert's thought processes and formulation of his or her opinion, I don't want my thoughts in any way, or the appearance that my thoughts might have affected or influenced that opinion.
This is a question. It doesn't necessarily have to do with the life of a lawsuit, but it might be of general interest. Edward Weinberger asks, what's the most important thing you look for when you decide to hire an expert? This may sound off the cuff, but the thing that impresses me most is when I contact an expert, do they call me back? His attorneys we need to have open lines of communication with an expert. When we are faxing information to prospective experts or calling them to gauge their interest in a case, if they call us back within 24 or 48 hours, we can generally, it's a good indicator that there might be a successful relationship. The other thing is the enthusiasm that they show for the process. And that's not necessarily a natural thing to be enthusiastic about litigation, but ultimately we need our experts to be enthusiastic about offering opinions, considering data, and working on the case.
And then one more question. Sean Fowler asked how an expert would convince an attorney that the expert should be involved early. And I know this can be potentially a sensitive issue. Different attorneys have different experts for the expert witnesses.
And different egos.
Right, different egos. Where we're more open to expert involvement, feedback from experts, other attorneys, frankly, just don't want to hear it. I think, it kind of goes to at the beginning of the relationship, the attorney-expert relationship. Both sides need to understand expectations. And I really appreciate when an expert witness is very open with me and says, hey, Nathan, this is how I operate. I like to be involved. I respect, how you're trying to litigate the case. If we can make this work, let's do it. Now, obviously, openness is the ideal there.
Just very quickly to summarize the Q&A, Ronald Stalick asked, have medical expert testimony ever been referred to state boards or medical societies for misleading testimony? I just came across that one, and what crossed my mind was the FinFin litigation, and they had echocardiograms that were being reviewed by some experts because the class action litigation had resolved itself, and they were just assigning damage points. And they determined that this one medical expert that was reviewing reports would have to review an EKG or an ECG, once every 15 seconds or once every 30 seconds, 24 hours a day, 365 days a year to actually churn out the number of reports that he did. And I think actually that judge might have sent the matter to the FBI for investigation for some type of fraud on the court. So I think, yes, there is always a possibility that whatever you write is going to be reviewed critically by others. But I think ultimately, if you tell the truth and are honest, you're not going to suffer any adverse effects down the road. We're going to jump back into the program now, and there'll be an opportunity for some more Q&A towards the end.
All right, we kind of wrapped up. The last thing we spoke about was written discovery. So there's also this phase, and there's really no particular order to them, but also some non-written discovery. And that will include primarily depositions. And likely that many of you have participated in depositions but depositions are just another tool that we as attorneys use to get valuable information to the case. And it can be very helpful for you as experts also in getting the data that you need to formulate your opinions. Typically, there's groups of people that are deposed. There's the parties, any fact witnesses, and then expert witnesses.
Oftentimes, experts are going to be deposed last
because their opinions are based on the facts and the testimony that will be given at the other deposition.
And that's why, the expert needs to say, well, you know what? I need you to ask this witness why they did something, because there's a number of reasons that might justify the outcome. In about a third of the folks on the call today are medical doctors or in the medical profession or nurses. And, there's a concept called clinical medical judgment, which is there are a number of choices to be made based on a number of facts, and all of them might be okay. And so we need to know why somebody claims they did something. Were they considering all of the facts and all of the data when they made a choice? If that's something you need to know, you need to tell the lawyers about it early so that they can ask those questions when the fact witnesses are being deposed. I think, experts always assume that the lawyers are going to ask all the right questions so that you can do your best job in offering an accurate opinion, but, we're not, we're not as smart as you think we are. We need some help, and oftentimes an expert can help us understand the framework within which the ultimate issues are going to be decided.
Right. So, experts are frequently called on to be deposed. Not all jurisdictions allow for the depositions of expert witnesses. So depending on where you practice or work, you may not be deposed all that often.
You may only be called upon to give a report, in which case your report would be even more significant. But here in our jurisdiction, the expert would submit a report and then also be subject to deposition.
And that's true in federal court as well. But an expert witness deposition is a great opportunity for you as an expert witness to add value to the case or take value away from the case.
And it goes both ways as often as not. And you have to understand as experts what lawyers' goals are at deposition. If I am taking an expert's deposition, I have possibly three goals. Number one, find out what you know. Number two, pin you down so you can't change your testimony at trial. And then number three, if I've got some impeaching information on you, I can either impeach you with it during your deposition to show the other side the weakness of their expert, or I can set you up for impeachment later at trial if I think that the case so those would be the goals that an expert or that a lawyer might have in deposing.
One thing to keep in mind, even though many of you are experienced experts, some may not be as experienced, the attorney should spend some time with you prior to the deposition getting you ready. That discussion should include, talking about the theory of the case, your opinions, getting an idea of what you're going to testify to.
Going over the pleadings, looking at the discovery, making sure that the attorney understands what your opinion is.
Because, if the attorney does not prepare with you, really you're being set up to fail at this deposition. If you don't have, he's not giving you every opportunity to succeed.
Don't assume that the attorney that hires you is going to protect your reputation. We know of cases where folks have paid good money to hire expert witnesses and in effect just thrown them to the wolves for lack of preparation. So I would insist that you spend time with your attorney before offering your deposition testimony to make sure that you're comfortable with the process that's going to take place.
Well, because that's the other great thing about the deposition is it bolsters not only the case but also your reputation as a witness. The other side is kind of feeling you out to see what kind of witness and how effective you will be down the road, either at trial or as they come to evaluate the case.
The other thing that I'll point out, and you all may or may not know this, but the plaintiff's bar and the defense bar collectively, each on their own fronts, have data banks of expert witness deposition transcripts from coast to coast. So if you have an expert that testifies often, I can guarantee that I can go online and in a matter of minutes I can obtain their deposition testimony in cases that they've testified in pretty much statewide. And so that's why it is important that you're prepared for deposition so that you can offer testimony that you're not going to be ashamed of if it's presented to you a year, 2 years, 3 years down the road. It's not unheard of that experts will offer varying opinions that are in fact contradictory of one another in different cases. And that is your goal, is to make sure that your opinions are scientifically valid and consistent no matter when you offer them. I mean, your opinions may vary based on different facts, but they can't vary based upon the direction that the wind's blowing in.
Well, and that goes back to that impeachment goal that Craig talked about.
As we move along in the life of a lawsuit, nearing the death of the lawsuit, we might settle a case. It's a fact that settlement is a reality. 95% of all lawsuits that are filed settle or are otherwise disposed of on summary judgment or through motion practice before a trial takes place. They don't often glamorize settlement of lawsuits on TV. Everybody's always in court trying their cases, but in reality, that's not what happens.
One of the mechanisms for reaching settlements is this alternative dispute resolution, or ADR. Some jurisdictions mandate that the parties participate in some form of ADR. Federal court, says by a certain date you have to have accomplished or completed mediation. And mediation is it's a non-binding meeting of the two sides. There's a neutral third party involved that kind of helps with the negotiation process, and the parties talk about, how much the case is worth. Arbitration is another form of that, except for unlike mediation, it is binding. The third party neutral that participates renders some kind of decision that binds the parties to do something. And there's different variations of this ADR, but the goal of ADR is for the parties to reach an amicable, as amicable as can be, I guess, resolution of the lawsuit short of trying the case.
Moving on to discussing the success or failure of experts in ADR, a strong expert opinion in a case, strong meaning favorable, is going to obviously make your position in settlement negotiations stronger. A weaker opinion where there are more unknowns, there are more variables, is going to oftentimes dictate taking a less favorable settlement. But the expert's role hopefully has been fleshed out and the work has been done before that ADR or mediation has occurred. We love mediation. I think it has gone a long way in the last 10 to 15 years towards clearing out otherwise clogged dockets and resolving lawsuits before trial. Lawsuits are incredible crucibles of pressure, not only on attorneys but on the litigants that are involved. It is an awful process to be a plaintiff or a defendant in litigation, particularly at trial, and that's why I think it benefits everybody to manage risk and to settle lawsuits during this ADR mediation phase.
And the things that you do as experts, rendering your opinions, preparing reports, giving your deposition, those things really affect what happens at this ADR in the settlement process. We frequently, in negotiations say, we cite to our experts. Our expert says this. Our case is looking good. Maybe they haven't retained an expert yet, or the expert hasn't rendered a good opinion. It really plays a big role on what happens in the settlement process.
And oftentimes the experts are not involved in that. I think it just bore mentioning today that the expert's impact on a case doesn't end after he signs off on the report and puts it in the mail or puts it on the fax machine. I mean, it goes on and it lives on. Next in the life of the lawsuit is certain death. Certain death. Somebody is going to win and somebody is going to lose when the jury comes back with a verdict. There is nothing other than a happy person and an unhappy person at trial. Trials where there's a winner and a loser and you kill the wounded. It's not necessarily the best way for disputes to end, but oftentimes it's the only way for disputes to end.
Well, and obviously I think most are acquainted with the trial process. What is interesting to think about is that an expert witness can be involved in every facet of the trial process, from jury selection all the way to the closing statements. Experts have a chance to give attorneys feedback on what things that should be said, questions to ask, where a case can go during the trial process.
And let me just reiterate, because I'm sure we'll get a lot of questions. This is not true of all experts. You have to be very clear whether or not you can operate as a consulting expert within the scope of what your lawyer has hired you to do. The state laws vary on discovery, on work product. Some states make everything that you say, every word that you utter, every note that you write discoverable to the other side. And that would be an instance where attorneys might want you to be a little more circumspect in the advice or assistance that you offer. But many states allow for these consulting experts and protect their expert opinions that they might offer as work product or trial preparation material. So that's where communication comes into play. The trial process, we've got jury selection, the opening statement where that's like the jigsaw puzzle on a puzzle box, and during trial little pieces come out and you put them together and the jury can refer back to the opening statement to see where all the pieces fit together. The plaintiff goes first.
Well, and the other thing is that the expert's opinion and the testimony that you'll eventually render is just one piece of that puzzle. Is the attorney, whether it's the plaintiff's attorney or the defendant's attorney, is kind of laying out what the end puzzle is all going to look like.
And, keeping in mind that in a traditional negligence case, negligence is also called tort. A tort is a civil wrong. In a negligence case, you'll have a duty. Somebody owes somebody a duty to be careful. There's hopefully evidence of a breach of a duty. The defendant might point out that, while there was a breach of a duty, it didn't cause any damages. Causation is an important element upon which many defenses hinge, that maybe there was a bad result, but it wasn't caused by any kind of a civil wrong. And then finally, there's damages. Damages are, what the plaintiff claims caused by the negligent conduct of someone else. The defendant gets and maybe call some experts to say that the standard of care was met, or that the standard of care wasn't violated, or that the standard of care, if there was a breach, didn't cause any damages. And that's where the experts get to come and offer their opinion at trial. There are a number of experts that don't want to show up for trial. They set their trial testimony fees so high that it is cost prohibitive in most cases for attorneys to hire them to come to trial, and in which case their deposition testimony is offered at trial and the actual witness doesn't have to come. From a trial lawyer's point of view, reading a deposition or putting on a videotape will put a jury to sleep faster than any combination of narcotics that we could administer to them. If you have a strong case, nothing beats a live expert to explain to the jury in terms that they can understand what's going on in a case or in the defense of a case.
And really the primary involvement, or the involvement that you think of most that an expert would have at trial is this giving of live testimony. And this is very, I can't even emphasize enough how important it is, because it's your chance to talk to whoever the fact finder is. Some cases it's the judge, a lot of cases it's the jury. You get to explain to whoever is the fact finder what your opinion is, what your opinion is based on, and how it affects the case.
We had a dental negligence case recently where we had retained an expert, and he had written reports, and he had opinions A, B, and C, and he gave some testimony, and he knew what he wanted. He wanted to frame the case and tell the jury E, F, and G. And we scratched our heads afterwards because as we asked him questions, we just could not get him to stay on track about A, B, and C. He was off in some other land talking about E, F, and G. And ultimately, after his testimony ran 3 times as long as it should have, we got him to explain to the jury what we had talked about, his opinions being A, B, and C. And I still to this day, I'm not sure whether we did a poor job preparing him or whether he just didn't grasp what our case was about. But something happened in our relationship with that particular expert where his testimony really was not understood well by ultimately a jury, because of this breakdown in his ability to explain his opinions in the way that a common man could understand.
Which is huge, because while he's talking, the judge and the jury, everybody is making a judgment call on his credibility. Do I believe this guy or not? And the more that he got off topic and rambled about stuff that we didn't ask about, the more his credibility dropped. And, that was a big deal for our case.
It sounded like we were deposing a politician because we'd ask a direct question, and he's our own expert, and he'd just give some other answer on some topic that he apparently was important to him. And it was just a bad experience that we had with our expert, and we talked with him about it afterwards, and I'm not sure that we ever got a really a good response on why that happened. Well, we're kind of approaching the end, guys, and we thought of an analogy to understand. Well, okay, we're going to do that. We're going to open it up for Q&A now, Matt. If you want to turn the question feature on. We've got, let's see here. One of the questions was, should this issue of how much information an attorney wants from us be covered in a retention agreement or an engagement agreement? And I think the answer is yes. Understanding how much or how little involvement the attorney wants in a case is critical to success in the relationship between attorney and expert. And I think that's going to be driven by the privileges that apply. Obviously, you know, when an attorney's not going to solicit your unbiased, unvarnished opinion of his case if he knows that anything negative that you offer to him is going to be discovered by the other party. And so I think that's an issue that's easily dealt with at the outset of a case, if not in the retainer agreement, but possibly orally.
Bob Stillerman asked a good question. Kind of goes back to the birth of the lawsuit and how parties are aligned. He asked how the court determines who's the plaintiff and the defendant when there's all these claims flying around. You got initial claims and counterclaims and cross claims. It's based on who files the lawsuit first and the order that the claims are made. So if one of my clients wants to file a lawsuit against somebody, they file first, they're designated as the plaintiff, and they name certain parties who are the defendants. Defendants, if they have claims against the plaintiff, they still remain defendants for purposes of the lawsuit, but they have affirmative claims against the plaintiff.
Let me give you an example. Let's say that you had somebody, plaintiff, sued a doctor for medical negligence, but that plaintiff, had an unpaid bill of $30,000. The doctor would be required to bring any claims that he has against the plaintiff in the same lawsuit, and the doctor would be designated as a counterclaim plaintiff for purposes of the claim for the fees that were due from that procedure. And so if you are the person asserting the counterclaim, you're a counterclaim plaintiff, and if you're the person defending, you might be called a counterclaim defendant. Here's a good question. Who asked that, Nathan?
That was William Nelson.
William Nelson. What rights does an expert have in a deposition, i.e. treatment by opposing attorney, legal representatives during the deposition? That's an excellent question. I think the rules require that attorneys behave in a civil manner. Now, that said, how many of you have ever been involved in a deposition with yelling and shouting and profanity and berating and browbeating and antics befitting of, high school, I suppose. An attorney that's putting you forth as a witness has the obligation, I believe, to make sure that you're treated with respect and that you're treated fairly. And if they don't do that, you as the witness can, say, look, we're going to have to get the court to intervene because I'm not going to be talked to like this or yelled at or cursed at, etc.
We've got quite a few questions about what exactly is discoverable, documents-wise, things that you've prepared or notes, things like that. And I think Craig mentioned this a little while ago. I just want to reiterate that it can vary. Some jurisdictions, have different rules depending on your role in the case. If you're a consulting expert versus a testifying expert.
The general rule, I think, if I were going to break it down, is a consulting expert where you are not necessarily going to offer testimony, but you're there to help the lawyer understand things that are beyond his expertise. Almost everything that you say or do is going to be protected. However, if you're a testifying expert, I think it could be argued that almost everything that you say and do and every letter that you write and every email that you send is potentially discoverable. Now, that varies widely from state to state. So that's why it is critical that you understand from the outset what is discoverable, what is not. And your attorney that hires you, if they can't answer that question for you, I'd be very afraid.
Well, because, I can think of a lot of depositions that I've attended of our experts where the other attorney asks for copies of letters we sent and they're retained at what have your attorneys talked to you about? What letters have they sent you? What have you looked at? And they want to see everything, every communication that we've had with this expert.
Here's a question from Ed Turner. It's interesting. Can a professional engineer licensed in one state testify as an expert in another state they're not licensed in? Well, from a legal standpoint, I suppose so. If the standards of care in building a building or engineering a bridge or a product are the same in both states, oftentimes, for instance, building codes vary from jurisdiction to jurisdiction, and that might be a problem. But building a safe building, I would hope that buildings are in one state as another. I think issues where you could be impeached if you were an Illinois engineer and you were going to testify about retrofitting a bridge for seismic activity in California that might be outside the scope of your expertise. From a professional licensure standpoint, I think you'd have to address that question with your licensing board, whether or not that would involve practicing engineering without a license in another state. But generally speaking, I think that to the extent that the standards of care are the same from state to state, you could do just fine.
Well, I think we're going to wrap up. We found that we thought of this little rhyme, and for those, I think some people are having some problems seeing the PowerPoint. We'll get with TASA and make sure the presentation is available after. We have this picture of a horseshoe nail. There's this little rhyme.
There's about 8 nails that go in a given horseshoe, and they all hold on one horseshoe, and a horse has 4 shoes.
But this old rhyme goes, for want of a nail, the shoe was lost. For want of a shoe, the horse was lost. For want of a horse, the rider was lost. For want of a rider, the battle was lost. For want of a battle, the kingdom was lost, and all for the want of a horseshoe nail.
The expert's role in the life of a lawsuit is one of the critical nails in the horseshoe that holds the horseshoe to the hoof of the horse or the lawsuit together, and that without solid expert opinions in complicated cases, there's no way for lawyers to maximize their ability to defend their client from someone trying to assert liability against them or to prosecute a claim. And I think once you understand the life of a lawsuit and the importance of an expert's testimony, I think it'll be encouraging to you to want to continue to do your very best in working on cases and to keep you enthusiastic about it.
And employed as an expert witness.
We appreciate you all for coming. Matt, I think you were going to say something about the next event to come. All right, Matt says we're going to look for an announcement on the second part of the introductory series. It's going to focus on expert fees, retention agreements, your relationship with the lawyer, starting the relationship. And we're going to send out a link to an archive on this webinar later this afternoon. And we're also going to send the presentation out via email.
I unmuted myself, so now everyone can hear me. First of all, we'd like to thank Craig and Nathan for dedicating an hour of their time today, but also several hours of their time before this. I think you guys did a great job, and we're looking forward to presenting more content to our experts. This is the first in a series of webinars that we will be hosting. We're planning on hosting, I believe, one a month, and opening them up to all of our experts. I think the content will get progressively more in-depth as we go along. We wanted to start off with a very general topic today, the life of a lawsuit, and as Craig said, the next time we're going to be talking about expert witness fees and the relationship between the expert and the attorney in a more in-depth manner. And we hope that you will join us each month as we provide this content to you. If you have any questions about this webinar or future webinars, please direct them to me, Matt Hyde. My email address is listed on the slide, mhyde@tasanet.com. We will be sending out a transcript, a link to the recording, and all the presentations that were presented during this webinar. Other than that, we again thank Nathan and Craig for their time, and we also thank you for giving up an hour of your day to join us today. Thank you very much.